when somebody comes into my office or calls me up, the first thing I do is just a breakdown of what happened. Basic overview, the client's or the caller's description about what happened. That gives me an idea of what sort of issues may be in play and what kind of things I might want to be looking for once I get into the case and get the paperwork from the prosecutor and can start looking at the details. The other thing that people always want to know is what's going to happen. And obviously I have no crystal ball. I can't predict exactly what's going to happen, and every case is different. But there are some things that are common to anybody who's been charged with a DUI in Washington, D.C. One thing that folks are always concerned about, understandably so, is what's going to happen to their license. Now in Washington, D.C., there's something called an implied consent rule. And what that means is when somebody refuses a breathalyzer test or is otherwise believed to have been operating a vehicle while impaired by alcohol, the Washington, D.C. Department of Motor Vehicles can issue an automatic suspension of their driving privileges. That is separate and apart from any proceeding in the D.C. Superior Court. So what that means is somebody's court case could be dismissed or they could be found not guilty, but the DMV could still have their license suspended. They're essentially two parallel tracks. So one thing we'll look at is what happened with the facts of their situation when they were stopped or when they were charged with a DUI offense, and what kind of paperwork did they receive? Are they looking at a hearing at the DMV? Now that suspension is automatic, but there's certain things we can do to demand a hearing, to challenge the evidence presented by the DMV, and to enable a person to retain their driving privileges.